Hi, this is Mike Kaplan from Kaplan Morrell with our weekly video posting. I call this Work Comp Wednesday, and happy 5th of July to everybody out there. Today's topic is litigation and what that means. We have a lot of clients who come in to our office and we're with various issues, and some need to be quote unquote litigated. And a lot of people don't necessarily know what that means. So today is a brief discussion regarding what does litigation mean in a work comp context. So from time to time, issues come up when we file a claim for workers' compensation benefits where the other side is contesting whether or not the benefit is due and owing. And when that occurs, if the parties can't resolve the issue, it is put on, one of the parties files an application for hearing, and that application for hearing endorses the issue that needs to be litigated, and those issues are what's called ripened in dispute. In other words, both parties are disputing it, and therefore it is ripe to have it adjudicated by a judge, which, by the way, a lot of people ask, do work comp cases, do they go before a jury? And I will tell you, no, we are in an administrative law venue, which means that when an issue is litigated, in other words, tried to the court, it actually is before just a judge. So that's called a bench trial or a bench hearing. So the individual who adjudicates the matter, in other words, decides who wins or loses, is an administrative law judge. Work comp claims can be at the outset contested, and what that means is that the insurance carrier or the respondent employer is not taking responsibility for the alleged work-related injury. And the threshold issue before an injured worker gets any type of work comp benefits is whether or not they were injured within the course and scope of their employment. Many times we need to go before a judge to have that issue determined, and from that issue, in the wake of that issue being determined, also determines what type of benefits the injured worker is entitled to. Now, when an injured worker is not, or should I say, when a insurance carrier does admit liability, meaning that a work-related injury has occurred, from time to time, between the time that the claimant files their workers' compensation claim and when the claim ends, there are various issues that become ripened in dispute. For instance, medical treatment. Medical treatment often goes to hearing, and the reason why is that a doctor, the injured worker's doctor, will recommend a certain treatment. Let's just, for purposes of today, let's say it's an MRI of the cervical spine. Well, the carrier has the either contest that, meaning they're taking a position that they're not going to pay for it, or they admit for it. If they admit for it, then there's no need for a hearing. However, if they contest it, if they state we're not going to pay for this MRI, then it puts the onus on the claimant and their representative to file for a hearing and get that matter adjudicated. And for that example, we would go to hearing to determine whether or not the work comp carrier or the employer should be ordered to pay for the MRI that is being recommended by the treating physician. So when an issue is being quote unquote litigated, what you need to understand is that a process starts by filing an application for hearing. That's when the process begins. Within 180 days of filing that application for hearing, a hearing should take place per the statute. And between the filing of the application for hearing and after actually going to the hearing, there's a lot of things that go on beforehand. Both parties are preparing their case, and the way that they prepare their case is that they engage in what's called discovery. And discovery encompasses a couple different things. One, questions going back and forth between the parties. Each party can send up to 20 questions to the other, which the intent of is to understand what the issues are, what facts are supporting the defenses of the issues and the issues themselves. And it's kind of a way for the parties to get a better understanding of the positions each are taking and the basis for them. those are called interrogatories. Another way to perform discovery is we have the ability to take depositions. And what a deposition is it's pretty much a where we sit down with a witness, whether it be a doctor or the claimant or an employer witness, and we start asking questions to them that they must answer truthfully. And really, in essence, when you take a deposition in context of litigating, that's when the hearing begins, because this is evidence that's on the record that the judge will consider when determining the final outcome of the issue that's right been in dispute. So depositions are also other tools that we can use while we're litigating. Now, I will tell you, as an injured worker, when you're just kind of hanging out there because after an application for hearing has been filed, you feel as though nothing really is happening on your case, when in opposite, actually a lot's happening in your case. You're just not privy to it, not because we don't want to tell you what's going on, rather it's just kind of a long process where we're getting prepared to go to hearing and put our clients in the best position to win at hearing. So litigation is something that is asked all the time by our clients, because we're in and out of litigation throughout people's claims, and it has a very, it's kind of elusive in regard to, what goes on and why it goes on. So today is just a little brief synopsis of what happens when an issue is litigated and why it's litigated and who hears the issue. So I hope that's really helpful for everybody. Check us out on the web at kaplanmorrell.com. If you have any questions or concerns about this video or anything, please ask questions. We're here to answer the public's questions, and we're here to help those who want and need more information about workers' compensation cases, as well as Social Security disability. So again, this is Michael Kaplan signing off. Hope you enjoyed this video.